Thank you so much, Chair. Thank you so much for having me, ladies and gentlemen. The speakers who came before me had a huge advantage. They could resort to norms and standards to give them a framework. We heard the reference to Article 19 and 2, and we referred to Article 6 of the ECHR. Now, I would like to talk about the field of soft law. And there isn't the standard we could start from. It's rather an opinion of mine or an experience that I have made. Maybe you know what I'm talking about because we were all judges or experts, and we know how hard it is to strike compromise every now and then. Compromise can be a time-consuming thing, and you need to come up with a compromise everyone is willing to sign. One of the most impressive examples was the struggle in the Venice Commission to reach a common understanding of what is to be understood as the European standard for independence of judges. We were 4 rapporteurs in that group: the Russian Constitutional Court President Zorkin, the Italian criminal law professor Nepi Modena, the retired Icelandic Supreme Court Judge Torfason, and myself. So 4 people, all in all. We were asked to issue an opinion on the independence of judges in Europe. The main problem was the split between the Eastern and Western European parts. While the Central and Eastern European countries were trying to build a new judicial system after the fall of communism in 1989, 1990, and the establishment of councils of judges and certain structural organizational arrangements were regarded as best practice for this purpose, while the so-called old democracies argued that, well, they could not accept certain objective and sensitive standards because they did not think it was necessary, and to translate them into systems that have been worked well, because you should never change a running system. Why should you make something new if this has worked well for decades? If a system works well without judicial committees, why should you establish judicial committees, by way of example? Now, the compromise was the following formula. Firstly, there is a variety of different systems for appointing judges in Europe, and there is not one single model that would apply to all countries. Secondly, in older democracies, the executive sometimes has a decisive influence on the appointment of judges. Such systems can work well in practice and allow for an independent judiciary because these powers are limited by legal culture and traditions, and they have evolved over time. However, new democracies have not yet had the chance to develop these traditions that can prevent abuse, and therefore, at least in those countries, explicit constitutional and legal provisions are needed as a safeguard to prevent political abuse in the appointment of judges. So that means the Venice Commission, that should have reached a common norm for everyone, had to use a compromise that works for Eastern and Western European countries. To me, this seems to be an element that, especially for the judiciary in Switzerland and in Germany, is of huge importance, because we're faced with those questions as to why we do not introduce standards and norms that other European countries have been demanding for many years. So this is to serve as an overview of the Venice Commission's work and the compromise from 2010. And against this backdrop, I would like to comment briefly on some cases in which the Venice Commission was called upon to answer questions, and they introduced some kind of constitutional fire brigade that should come to the rescue and extinguish fires if need be. And I would then like to talk about some methodical questions. Well, I said I wanted to provide you with examples. The first example is Albania. The initial situation was as following. There is a high level of dependence and corruption in the judiciary, which is an endemic problem and has been an endemic problem for many, many years. In some cities, judges applying for a certain judgeship had to pay for those vacancies, and it was sometimes a very large sum of money. It was a lot for the judges or the candidates. Now, this situation should stop. They wanted to introduce a vetting procedure that would have to be done for the already appointed judges and the new judges that wanted to be appointed. So not only starting now, but also in hindsight going back 20 or 30 years. And it also entails the disclosure of their financial assets, not just their own, but also their relatives' financial assets. So it should be a comprehensive vetting procedure done by an independent body. So if someone owns an apartment, but they cannot prove what they had earned to afford that apartment, then this was something one should see into. Some of the judges failed this vetting procedure, and in the Supreme Court, basically no one was left there anymore because they failed the vetting procedures. There was only one female court, but her mandate actually had expired, and that was at the Constitutional Court. So judges or new judges couldn't be appointed anymore because the replacement of the Constitutional Court should have been done by a certain formula, 1/3 President, 1/3 Parliament, 1/3 Supreme Court. So again, the Venice Commission was initiated as a constitutional fire brigade, but basically it did not help the courts. It emptied the courts. In this case, the Venice Commission tried to interpret the Constitution so that the Supreme Court and the Constitutional Court were still functioning. But again, this example of the vetting procedure shows that even the best ideas can have very bad consequences, the best intentions basically. Empty courts in Albania would have led to a non-existing judiciary. My second example is from Russia, a new example. The Russian constitution was amended, and these amendments are being checked by the Venice Commission as we speak. These amendments also affect the judiciary in Russia. What is new is that the president of the Russian Federation has the right to nominate courts or to remove courts in the Constitutional Court, in the Supreme Court, different courts, different judges. The initiative can start with the president. The requirement is as such: violation of the honor and dignity of a judge, as well as in other situations established by law, which show that the judge is incapable of continuing to perform their duties. That's the requirement. So you will likely end up with two basic problems: the dependence of the judiciary on the executive. Not only talking about the appointment, I'm talking about the removal of judges if the president believes this should be done. And the requirements are quite vague in general. And it is not a European standard, because a European standard says that the definitions have to be very clear and the conditions need to be very clear why a judge has to lay down their mandate. So again, the Venice Commission was requested, and I believe that these examples alone Also, on a constitutional level, these examples show that the tendency goes toward a weakening of the judiciary and a growing dependence of the judiciary on the executive. My third example is Poland. My predecessors, well, the speaker before me talked about this before. It was in connection with the ECJ. Reforms came from the Constitutional Court. There were reforms of the Supreme Court and reforms of general legislation. And the Venice Commission has accompanied the entire process and issued clear statements and opinions. There was an opinion in 2020. It was about the prohibition to doubt that a judge appointed by the president is a legitimate judge. A violation of this leads to a disciplinary proceeding. So it was not allowed to voice doubts whether or not an appointed judge is legitimate. This would end up with a new extraordinary chamber of the Supreme Court. But this would lead to a situation where the vetting process lies with the same body. And this body is already in a situation where it cannot decide independently and impartially. So these examples, I believe, show that the Venice Commission is resorted to as a constitutional fire brigade, and these examples also show the dimension of the threat of judicial independence in Europe. So what's the function of the Venice Commission? Well, its mission is to issue concrete opinions on current problems it is presented with, referring to independence of judiciary systems. Besides these very concrete tasks, the Venice Commission also should voice abstract standards or define standards that serves as a skeleton to these clear and clearly defined statements and opinions, like the opinion on the judicial independence from 2020. It completely includes the legislation of the ECTHR. It is copied by the Venice Commission, also legislation from the ECJ and international standards like the UN Basic Principles on the independence of the judiciary and further soft law standards. They all flow together, so the Venice Commission can use it to come up with something that can be seen as a European standard. The method is, of course, problematic because we talk of European standards, but non-European standards assess the statements and different soft law instruments that need to be linked together. So the idea of European standards is, of course, a vague requirement that is evolving. To what extent is the Venice Commission's approach successful? Well, it fills a void. The ECJ, Mr. Voss said it before, the ECJ is or has become a court deciding on the state's legitimacy. So now the Venice Commission has filled a void. I believe its track record is mixed. In the case of Albania, certain standards have been adopted, and they took the Venice Commission's opinion as an orientation. Sometimes the Venice Commission's success is of medium-term nature because it starts off as soft law and it becomes hard law, so to speak. But Poland, for instance, is not a success for the Venice Commission. Well, I mentioned these three countries, but we're here to talk about Germany and Switzerland. We have similar questions concerning judicial independence. We talked about the Court of Wiesbaden. This court questioned the state of independence in Germany. So we are faced with different challenges in the different European countries. And the big problem is to develop general standards. I believe that there are very well-defined standards. For instance, presidents are not allowed to initiate the removal of judges, but certainly we can discuss the appointment procedure of judges. As to the opinions of the Venice Commission and the development of standards, and this is very important to me, this is what the Venice Commission sees it as rule of law checklist. I believe the rule of law checklist is quite helpful because the rule of law, of course, comes with different interpretations, but the checklist consists of, well, different topics: legality, legal certainty, prevention of abuse of power, equality of rights, prohibition of discrimination, and access to the court, and also independence and impartiality. So what does it do, or how does it work? It develops questions for that rule of law checklist. And these questions, or the checklist, is to be seen as the yardstick that one can apply to assess a state's judicial independence. It's 24 questions that are considered central. Regulations on judicial independence, for instance, the appointment and dismissal of judges, their terms of office, reasons for their removal. Is it appointment for life or limited? Reasons for dismissal, I said that before. And of course, also appeal against dismissal. And this is a central point. This boils down to a legal tradition or a legal culture. Whether or not judges are seen as independent and impartial or the opposite, well, this also boils down to whether or not there is a basic trust in a given country. Is the judiciary considered independent by the population? What is public opinion with regard to possible political influence and manipulation in the appointment or promotion of judges, as well as in their decisions in specific cases? These questions are central. And this boils down to what I refer to as a legal culture. Appearance is very important. Disciplinary proceedings can be used as breaks in a certain country.